States Constitution, a presentation by Tracy Ballard. What is the Supremacy Clause? The Supremacy Clause is a clause in the Constitution which gives the Constitution authority over state law. The Supremacy Clause is officially known as Clause 2 of Article 6 of the United States Constitution. The Supremacy Clause establishes that state laws are subordinate to federal laws. What is the origin of the Supremacy Clause? The Supremacy Clause has a basis in the Articles of Confederation, specifically Article 13 of the Articles of Confederation. James Madison enumerated the reasons why a Supremacy Clause is necessary in Federalist Paper 44, and during the founding of the United States, it was decided that the states should be subject to federal law, not the other way around, or the federal system would not work. How has the Supremacy Clause evolved over time? The Supremacy Clause was an original component of the Constitution, but the actual effect of the clause on United States law was not wholly understood at the beginning. The powers attributed to the federal government by the Supremacy Clause have been clarified and even extended by decisions that have been rendered by the United States Supreme Court. Next, we will examine several of the most important decisions that have affected the modern interpretation of the Supremacy Clause. The first case we're going to discuss is Ware v. Hylton of 1796. This case was the first incidence of state law being invalidated due to conflict with federal law. Ware v. Hylton was a case that was brought before the Supreme Court in 1796 regarding debts owed to foreign interests that were derived from the American Revolutionary War. Virginia had passed a law nullifying debts owed by American citizens to foreign citizens or companies. This contradicted the peace treaty agreed to by the federal government, which ended the war. The Supreme Court ruled that the treaty, which had been enacted by the federal government, overruled the state law. Next we have Marbury v. Madison of 1803. This very important landmark case established the precedent that Congress cannot pass laws contrary to the Constitution, and established the Supreme Court as the ultimate arbiter of such issues. Marbury v. Madison was a very interesting case in which the Supreme Court clarified and expanded its powers by limiting its own power, which actually sounds pretty weird. The case was initiated by William Marbury, who claimed that he was improperly denied a Justice of the Peace Commission. The Supreme Court agreed that Marbury had been wronged, and the denial of the commission was illegal and a failure of the government to fulfill its duties. But they also found that the congressional act which put the case in the jurisdiction of the Supreme Court was unconstitutional. So, by denying the legality of the law, which expanded Supreme Court jurisdiction, the Supreme Court established that a law passed by Congress could be invalidated if the Supreme Court found that the law contradicted the U.S. Constitution. Next we'll look at two cases that are similar. One was Martin v. Hunter's Lessee of 1816, the other Cohens v. Virginia of 1821. These two cases established the precedent that states cannot pass laws contrary to the Constitution, and established the Supreme Court as the ultimate arbiter of such issues, including civil law cases. Martin v. Hunter's Lessee and Cohens v. Virginia were seemingly disparate cases, one involving the confiscation of land and the other involving the sale of lottery tickets. But both were key rulings that established state courts as being subject to decisions made by the Supreme Court, one for civil matters and one for criminal matters. In both cases, states passed laws that contradicted federal laws, and state courts held that federal laws could be blocked by state laws, and that state courts were not subject to the jurisdiction of the Supreme Court of the United States. The Supreme Court did not agree with that interpretation and informed the state courts that they were indeed under the jurisdiction of the Supreme Court of the United States. Next, let's look at McCulloch v. Maryland of 1819. This case established that states cannot tax federal institutions. McCulloch v. Maryland was a case that involved the state of Maryland attempting to place a tax on federal currency issued by the Second Bank of the United States for those banknotes that were issued by the branch of the bank that was located in Maryland. Maryland argued that a national U.S. bank was not expressly authorized by the Constitution and was not a legal institution. The Supreme Court ruled that the bank, although not specifically authorized, was allowed to be operated under the powers granted to the federal government by the Necessary and Proper Clause of the Constitution, and that further state governments were not permitted to tax federal institutions because that could make the institutions unworkable if every state was allowed to levy a tax on them. Or, as the court put it, the power to tax is the power to destroy. Next, let's look at Ableman versus Booth of 1859. This case established that state courts cannot issue rulings that contradict the rulings of federal courts. Ableman versus Booth was a case in which state courts in Wisconsin declared that a federal law was unconstitutional, and this ruling was upheld by the Wisconsin Supreme Court. The state Supreme Court decision was appealed to the United States Supreme Court, which ruled that all state courts are subject to federal jurisdiction and may not overrule federal court decisions or federal law, and that all levels of federal courts had authority over all state courts, even state Supreme Courts. Finally, let's look at the case of Reid versus Covert of 1957. This case held that the United States Constitution supersedes international treaties. Reid versus Covert involved an agreement between the United States and the United Kingdom that allowed trial by military tribunal of not only military personnel, but also of their dependents. The Supreme Court ruled that international agreements or treaties that abridged the constitutional rights of citizens were not enforceable, and that a U.S. civilian citizen's right to a trial by jury could not be waived by any treaty or agreement, even if the offense occurred on foreign soil. So what is the future of the Supremacy Clause, and how does it affect our nation today? The Supremacy Clause establishes the federal government as having legal authority over the states in all matters except those that are relegated to the states, either expressly or by default. This model of government is the basis of our entire legal system and is ingrained in our society in many ways. Without the effects of the current and historic interpretation of the Supremacy Clause, our federal system of government would be much less efficient and possibly not workable at all. Even after over 200 years, our Constitution seems as strong as ever and will remain so for the foreseeable future, thanks in large part to the concept of federal supremacy over state laws, which acts as a stabilizing force to balance states that enact extreme laws in one direction or the other. And to highlight that concept and provide further enlightenment, this subject should be revisited in another 200 years. Now, to end this presentation, please enjoy reading this bibliography. And I thank you for watching this presentation presented by Tracy Ballard and the United States of America. Good day.